Injury cases typically go through what we call 3 phases. The first phase is what we call the pre-demand phase. That's the phase that begins when the client first contacts us and we conduct our investigation. We are notifying witnesses, getting witness statements. We're engaging experts as may be necessary and private investigators. We establish a relationship with the insurance companies and the adjusters with whom we'll ultimately be attempting to negotiate a resolution. And during that phase of the case, that pre-demand phase of the case, the client, in the case of someone who's injured, is getting their treatment. So we're monitoring their treatment. We're assisting them with treatment decisions to the extent that it's appropriate. I mean, sometimes people want to delay having surgery. They may want to get, second or third opinions, which obviously is a good thing. So we're helping monitoring their treatment. Once they finish with their treatment, they reach what's called MMI, which is called maximum medical improvement. And that doesn't mean that a person has gotten any better. It simply means that medically they've reached a point where no further medical care can improve their condition. At that point, we then get all of the final medical records. We get the medical reports with the opinions of the physicians detailing the nature and extent of the injury, and the case gets transferred into the second phase, and that's what we call the demand phase. This is the phase of the case where we try to resolve the case without filing a lawsuit. Most of the cases are resolved in the demand phase because we do such a good job working the cases up, building the case up, investigating the cases in the pre-demand phase. Most of the cases get resolved in the demand phase, and essentially what we do is we prepare a demand letter. Our clients get to participate in that process. This is another thing that distinguishes our law firm. We actually send a copy of that demand letter to the client so they can review and comment on it. We do that because it gives them an opportunity to ask questions about why we do certain things in the demand. So they feel more comfortable and more educated about that process. And sometimes the clients come up with some additional facts which are very helpful in presenting their case. So they participate in that demand process. That demand goes to the insurance company, and we make a monetary demand, of course, and we hope to resolve the case. There's negotiating back and forth, which the client is always involved in. The client is the one, not the attorney, not me or anyone in my office, who decides whether the case settles or it doesn't settle. I make recommendations to the client based on my knowledge, training, and experience, but I respect the fact that I work for the client, and it is the client's decision that matters, not mine. The client has the final say as to whether we settle a case or we go to the next step, which is the litigation phase. This is the phase of the case where we actually file a lawsuit in court, and we go through the discovery process where we exchange documents, we take depositions, which is where we ask people questions under oath. We go to a mediation, which is a formal settlement conference, and if the case doesn't settle at mediation, we then set the case for trial. Most cases that don't settle at mediation settle before trial, and the fact is that most cases settle before they go to trial. I personally try all my own cases. I'm not afraid to try cases. I enjoy trying cases, and I feel most comfortable and most natural in the courtroom. I mean, that is my element. But what's important for the clients to know is this. Just because I enjoy trying cases, just because the attorney may like trying cases, doesn't mean the case should go to trial or needs to go to trial, because the primary concern is following the wishes of the client. And in order for an attorney to determine what the client wants, the attorney first has to ask, and the attorney then has to listen to figure out exactly what that client wants, because everyone is different. So you can't take a cookie-cutter approach to these cases. I don't care how similar the facts are. Every case is different. Every person is different. We've done this thousands of times. I like to tell the people in this office, we should be anticipating the need. We should be answering the question typically before it's even asked. because we've experienced it so many times. So our preparation of the case and our preparation and education of the client is designed to take that into consideration. When I hear people say in response to my question, do you have any questions? And they'll say, well, no, you've answered all of my questions. That means we've done a good job. That means that we've anticipated what that need is, what those questions are, and we've addressed it before the client has even asked about it. And again, that is an indication of just good preparation.